Chapter 45 Appeals and Bail Pending Appeals 1. Introduction. An appeal is a review of the trial proceedings by an appellate court to see that the proceedings were carried out according to law. The appellate review is conducted on the written record of the trial court, without the attendance of witnesses and, ordinarily, without the accused being present. Appeals are creations of statute. Accordingly, rights of appeal and the jurisdiction and powers of courts of appeal are restricted to what has been expressly conferred upon them by legislative authority. In criminal matters, the legislation dealing with appeals from indictable matters is set out in Part 21 of the Criminal Code. The Court of Appeal for Ontario hears indictable appeals. The practice and procedure in indictable appeals are contained in the Criminal Appeal Rules. Appeals from summary conviction cases are dealt with in Part 27 of the Code. Summary conviction appeals are heard before the Superior Court of Justice. The procedure for these appeals is contained in the Criminal Proceedings Rules for the Superior Court of Justice Ontario SCJ Rules 1.1 Jurisdiction. It is the nature of the proceedings that determines the forum for the appeal. When one is in doubt as to whether the trial was proceeded with summarily or by indictment, an examination of the information should reveal the manner of proceeding. All cases involving indictable proceedings are appealed to the Court of Appeal for Ontario, regardless of where the trial was held. There are three common situations in which even experienced lawyers may mistakenly file an appeal in the wrong court: where the offense is within the absolute jurisdiction of a provincial court judge under S. 553 of the Code and the Crown proceeds by indictment, although the case is tried in the Ontario Court of Justice. The proceedings are by way of indictment where the accused elects to have an indictable offense tried before a provincial court judge pursuant to S. 536 of the Code. The election does not affect the indictable nature of the proceedings when an accused person is charged with and tried for an indictable offense, but is convicted of a lesser summary conviction offense. The appeal will still be heard in the Court of Appeal because the proceedings were by way of indictment. On occasion, an accused person may wish to appeal convictions or sentences from both summary and indictable offenses that arose out of the same circumstances and were dealt with together before the same judge. In order to avoid an unnecessary duplication of the appeal process, S. 675, 1.1, of the Code permits an appeal from a summary conviction matter to be heard by the Court of Appeal, with leave of the court or a judge thereof, where it was tried with an indictable offense and there is an appeal in relation to the indictable offense. 2. Indictable Appeals 2.1 Rights of Appeal 2. 1. By the accused. An accused person may appeal against the accused's conviction on the following grounds: a question of law alone. S. 675, 1. I. Examples of issues that have been found to involve questions of law include the availability of a defense, the admissibility of evidence, the interpretation of a statute, and a ruling as to whether the accused's rights under the Canadian Charter of Rights and Freedoms, Charter, were infringed. A question of fact or mixed fact and law, with leave of the Court of Appeal or a judge thereof. S. 675, 1. 2. An example of a question of fact is the sufficiency of the evidence to support a conviction. A common ground of appeal involving a question of mixed fact and law is the admissibility of a confession. Any ground that appears to the Court of Appeal to be sufficient, with leave of the court. S. 675, 1. 3. Issues that have been dealt with by the Court of Appeal under this rubric include incompetent representation by defense counsel and improper cross-examination by Crown counsel. An accused may also appeal against the accused's sentence, with leave of the Court of Appeal or a judge thereof, unless the sentence is one fixed by law. S. 675, 1. B. Note that a sentence appeal is not restricted to matters such as the imposition of a jail term or its length. The term sentence has been extended by S. 673 of the Code to other dispositions, including weapons prohibitions, driving prohibitions, restitution orders, and the terms of a probation order. The Code does not set out any specific grounds upon which a sentence appeal must be taken. Although leave to appeal is a requirement for some appeals against conviction and all sentence appeals, the Court of Appeal for Ontario ordinarily does not require the question of leave to be argued separately from the appeal itself. An exception to this general rule occurs in relation to appeals against sentence only, where the appellant is seeking bail pending appeal. The issue of leave to appeal must be determined before the appellant can be granted bail. In general, the leave application will be heard together with the application for release. The importance of the leave application should not be underestimated. Since a denial of leave to appeal by a single judge of the Court of Appeal cannot be appealed to the full court 1. 2 by the Crown may appeal the following. An acquittal on a question of law alone. S. 676. 1. An acquittal includes a situation where the accused was acquitted of the full offense, but convicted of a lesser and included offense. S. 676. 2. An order quashing an indictment or failing to exercise jurisdiction on an indictment. S. 676. 1. An order of a trial court staying proceedings on an indictment or quashing an indictment. S. 676. 1. A sentence, with leave of the court or a judge thereof, unless it is one fixed by law. S. 676. 1. D. 2.2 Procedure on appeals. Although some appellants pursue their appeals without the assistance of counsel, this section will focus on the procedure involved in appeals where the appellant is represented by counsel. 2. 1. The stages of an appeal. The criminal appeal rules set out the steps to be followed to ready an indictable appeal for hearing. This procedure, called perfecting the appeal, is designed to ensure that all of the material necessary for a proper hearing will be put before the court. Once the appeal is perfected, a hearing date can be obtained from the court. Notice of appeal. In order to launch an appeal, a notice of appeal or notice of application for leave to appeal in Form B must be filed. The notice must set out the particulars of the conviction, the grounds of appeal, and the appellant's address for service. Rule 4 sets out the time requirements for service of this document. In general, a notice of appeal must be served and filed with the Court of Appeal within 30 days of the order under appeal. However, a notice of appeal from conviction does not need to be served and filed until 30 days after the sentence is imposed. R4. 2. Pursuant to S. 678. 2. Of the Code. R7. 1. And S. 6.1 of the Practice Direction concerning Criminal Appeals at the Court of Appeal for Ontario Criminal Appeals Practice Direction. A judge of the Court of Appeal may extend the time within which a notice of appeal must be filed. An appellant in a solicitor appeal serves the notice of appeal by sending 3 copies by mail to the registrar of the Court of Appeal or by delivering them to the office of the registrar. Though the criminal appeal rules do not require an appellant to serve the notice of appeal on the Crown, it is the routine practice of most appeal counsel to do so. In a Crown appeal, the accused must be personally served with the notice, and 3 copies must be filed with the registrar, together with proof of service on the accused. R5. B. Transcripts. Cases before the Court of Appeal are argued on the basis of a complete or partial transcript of the trial proceedings. R8. In general, an appellant is required to file a certificate from an authorized court transcriptionist, indicating that 5 copies of the transcript have been ordered, either at the time that the notice of appeal is served or within 15 days of filing the notice of appeal. A failure to comply with these requirements may result in the registrar taking steps to have the appeal dismissed as abandoned. R9. The contents of the transcript for an appeal are set out in RR 8, 8, 11, and S 9.3 of the Criminal Appeals Practice Direction. It should be noted that certain portions of the trial proceedings omitted from the transcript under R8, 8, such as the jury selection or counsel's closing addresses to the jury, are often relevant to the issues on appeal. Accordingly, if a ground of appeal pertains to one of these areas, counsel should seek an order from a judge of the Court of Appeal or the consent of the Crown for its inclusion in the transcript. Once the transcript has been completed, the transcriptionist will notify both parties and the registrar. The transcriptionist will deliver the court's copies to the registrar. The appellant must serve the transcript on the respondent. Personal service is not required. The permissible forms of service are set out in S 5.2, 3, of the Criminal Appeals Practice Direction. C. Appeal Book. The Appeal Book is a collection of all of the significant documents relating to the trial proceedings. In order to prepare it, the appellant must file a requisition with the trial court, requiring the court to forward all of the documents and exhibits capable of reproduction to the registrar. R11. The contents and form of the appeal book are set out in R14. D. Factums. A factum is a written statement of the party's position on the appeal. It is designed to give the Court of Appeal an appreciation of the facts of the case and the legal issues prior to oral argument. Rule 16 governs the form and content of factums. In appeals from conviction alone or conviction and sentence, the factums contain a statement of the case, a summary of the facts, a statement of the issues to be raised and the applicable law, the order requested, and appendices of the authorities to be cited and the relevant legislative provisions. The factum for a sentence appeal must be in Form D. R17. The main difference between a sentence appeal factum and other factums is that it begins with a list of factual recitals, which provides a quick picture of the case, before moving into a review of the facts and the legal issues common to all factums. All factums must be dated and signed. No factum can exceed 30 pages in length without an order from a judge of the Court of Appeal. Criminal Appeals Practice Direction. S 9.7. 7. Where a factum does not comply with the criminal appeal rules, it will not be accepted for filing at the Court of Appeal. The Court of Appeal requests that counsel file an electronic copy of all factums. Criminal Appeals Practice Direction. S 9.7. 9. Guidelines for filing electronic documents at the Court of Appeal for Ontario, March 1, 2017. E. Perfection of the appeal. An appeal is perfected and can be listed for hearing when copies of the transcript, appeal book, appellant's factum, and certificate of perfection have been served on the respondent and filed with the Court of Appeal. R18. In general, the appellant must perfect the appeal within 90 days after delivery of the transcript to the Court of Appeal, unless a longer period of time is permitted by a judge or the registrar. Particularly in appeals from long or complex trials, it is common for appeals to take longer than 90 days to perfect. In sentence appeals and appeals from a decision of a superior court of justice judge not sitting as a trial judge, the time frame for perfection is shorter. R18. 4. Failure to perfect an appeal in accordance with R May 18 led to the appeal being dismissed as abandoned or the appellant's bail being revoked. R20. 2.3. The hearing. The Court of Appeal for Ontario generally sits in panels of 3 judges. During the hearing of the appeal, counsel, who are robed, are able to expand upon the legal propositions they have set out in their factums. In appeals from conviction and from acquittal, the court reviews time estimates provided by the parties and notifies counsel of the amount of time allocated for oral argument. All other appeals have fixed time limitations for oral argument. Sentence-only appeals are restricted to a half hour in total. Other appeals, to a total of 1 hour. When the oral argument is completed, the court usually retires to consider its decision. On resuming, the court may render judgment from the bench. If the court wishes to consider its decision further, it will reserve judgment. The court will advise counsel when the judgment is ready to be released. 2.4 Powers of the Court of Appeal. 2. 4. 1. Power to receive evidence. While most appeals are argued solely on the basis of the trial transcript, S 683 of the Code permits a Court of Appeal to order the production of documents, to direct that witnesses attend, and to admit the evidence of any witness, where it is necessary in the interests of justice. The most significant aspect of the court's powers under S 683 is the ability to receive fresh evidence. Fresh evidence usually consists of new information relevant to a determination made at trial that came to light after the case was heard. In order to be admissible, fresh evidence must meet the following 4 requirements. 1. The evidence could not have been introduced at trial through the exercise of due diligence. 2. The evidence is relevant, since it bears on a decisive or potentially decisive issue at the trial. 3. The evidence is credible. 4. When considered together with all of the other evidence led at trial, the fresh evidence could reasonably be expected to have affected the verdict. Either defense counsel or the Crown may seek to adduce fresh evidence, where the Crown applies to admit fresh evidence. The first requirement, due diligence, will generally be applied more strictly. In order to put fresh evidence before the court, the applicant will place an affidavit containing the new information in a sealed envelope, which is served on the respondent and filed with the court, along with a notice of application. Criminal Appeals Practice Direction. S 7. 3. 5. The respondent has the right to cross-examine the affiant, and the transcript of the cross-examination must also be placed in a sealed envelope and filed with the court. At the start of the hearing, counsel will argue whether the fresh evidence should be admitted. If the motion to adduce the fresh evidence is not dismissed, judgment on its admission is reserved, and the appeal is heard. This permits the court to assess the fresh evidence in the context of the case as a whole. If the fresh evidence could not reasonably have affected the verdict, the motion will be dismissed, and the case will be dealt with on the basis of the other grounds of appeal. If the fresh evidence is of sufficient weight that it might have altered the result, the fresh evidence will be admitted, and a new trial ordered. The court's approach to fresh evidence is somewhat different where the evidence is directed to the validity or fairness of the trial proceedings, e.g., where there are allegations of juror misconduct, Crown non-disclosure, or incompetent representation by defense counsel. Fresh evidence of this type is received in the interests of justice without meeting the 4 traditional requirements. However, the admission of this evidence does not determine the outcome of the appeal and automatically lead to a new trial. Instead, the fresh evidence is considered in conjunction with the trial record in determining whether the appellant has established a miscarriage of justice. In sentence appeals, fresh evidence applications by an accused often relate to events subsequent to the sentence or consist of information from the correctional institution regarding the accused's progress. The Crown may consent to the introduction of such fresh evidence where the facts reported are not controversial, while the court may take into account the fact that the Crown has consented. The fresh evidence will only be admitted where the court is satisfied that all 4 requirements are met. 4. Power to dispose of appeals. The powers of the appellate court in disposing of appeals generally parallel the rights of appeal, described earlier in this chapter. Conviction. A court of appeal may allow an appeal on the following grounds: the verdict is unreasonable or unsupported by the evidence. S. 686. 1. The function of an appellate court under this provision is to determine on the whole of the evidence whether the verdict is one that a properly instructed jury, acting judicially, could reasonably have rendered. Accordingly, the court must examine and evaluate the evidence adduced at trial in assessing the reasonableness of the verdict, while giving recognition to the advantageous position of the judge or jury, who heard and saw the witnesses. There is a wrong decision on a question of law. S. 686. 1. 2. The mere existence of an error of law will not be sufficient to successfully invoke this clause and award a new trial. It must be shown that the legal error caused prejudice to the accused and that it affected the verdict. There has been a miscarriage of justice. S. 686. 1. 3. A miscarriage of justice has been held to occur when there is an appearance of unfairness in the trial proceedings, even where no actual prejudice to the accused occurred. In allowing an appeal, a court of appeal can enter an acquittal or order a new trial. S. 686. 2. The Court of Appeal will dismiss an appeal where none of the grounds set out in S. 686. 1. Has been made out. In addition, in recognition of the fact that no trial is perfect and justice is served so long as an accused's trial is a fair one, the court has the power to dismiss an appeal where there was a wrong decision on a question of law, provided it gave rise to no substantial wrong or miscarriage of justice. S. 686. 1. B. 3. In exercising this power, the court will consider the seriousness of the error, the effect it likely had on the jury's reasoning, and the probable guilt of the accused on the basis of the properly admissible evidence. Similarly, an appellate court may dismiss an appeal where there was a procedural irregularity at trial that caused no prejudice to the appellant. S. 686. 1. B. Acquittal. In an appeal from acquittal, the onus is on the Crown to satisfy the appellate court that but for the error of law, the verdict would not necessarily have been the same. In allowing an appeal by the Crown, the Court of Appeal has jurisdiction to order a new trial or, in cases tried by a judge alone, to enter a conviction. S. 686. 4. To secure a conviction on appeal, the Crown must demonstrate that the accused should have been found guilty but for the error of law by showing that all of the findings necessary to support a conviction had been made, either explicitly or implicitly, or were not in issue. Alternatively, the court may dismiss the appeal. C. Sentence. The fitness of the sentence is the sole consideration in a sentence appeal. An appellate court will only interfere with a trial judge's sentencing discretion where there is an error in principle or error in law that has an impact on the sentence, or where the sentence imposed by the trial judge is a substantial and marked departure from the sentences customarily imposed for similar offenders committing similar crimes. When dealing with a sentence appeal, the Court of Appeal may dismiss the appeal or vary the sentence. S. 687. The power to vary a sentence permits the court to increase or decrease the penalty imposed at trial. Accordingly, in a defense appeal of the accused's sentence, the Court of Appeal has the ability to increase the accused's disposition at the request of the prosecutor, despite the failure of the Crown to file its own notice of appeal. This power is rarely exercised, but is an outcome the accused must be made aware of before instructing counsel to launch a sentence appeal. 2.5 Further appeals. The jurisdiction of the Supreme Court of Canada to determine appeals from indictable offences is set out in SS 691-695 of the Code. The procedure for such appeals is contained in the Supreme Court Act and the rules of the Supreme Court of Canada. All appeals to the Supreme Court of Canada are restricted to questions of law alone. In very limited circumstances, an appellant will have an appeal as of right to the Supreme Court of Canada. For example, S. 691, 1, of the Code gives an accused a right of appeal on a question of law on which a judge of the Court of Appeal dissents. However, in the vast majority of cases, leave to appeal will be required. SS 691 and 693. An application for leave to appeal to the Supreme Court of Canada is an entirely separate proceeding from the appeal itself. In general, leave applications are made only in writing. 3 members of the court review the materials filed in the leave application and grant or deny leave without providing any reasons for their decision. Leave to appeal is not routinely given and is only granted in cases that raise questions of national importance. 3. Summary conviction appeals. In many respects, the procedure involved in summary conviction appeals is the same as that for indictable appeals. This section will focus on the areas of distinction between the two types of appeals. 3.1 Rights of appeal. There are 2 routes of appeal in summary conviction matters. The majority of appeals are launched pursuant to S. 813 of the Code. The narrower and less frequently used form of appeal is by way of S. 830. 3. 1. Section 813 appeals pursuant to S. 813. An accused person may appeal a conviction, order, or sentence. This is a broad right of appeal, with no leave requirements or other restrictions. The Crown may appeal from the dismissal of an information, a stay of proceedings, or a sentence. S. 813. B. Unlike the situation in indictable appeals, in summary conviction proceedings, the Crown has a right of appeal on a question of fact, mixed fact and law, or law alone. R.V. Labadie. Despite the breadth of the statutory appeal, deference is owed to the findings of fact of a trial judge. 3. 1. 2. Section 830 appeals pursuant to S. 830. The accused and the Crown can only appeal in 3 narrow circumstances: where there is a question of law alone, an excess of jurisdiction, or a refusal or failure to exercise jurisdiction on the part of a trial judge. By filing an appeal under S. 830, an appellant is deemed to have abandoned the right of appeal under S. 813. S. 836. 3.2 Procedure on appeals. 3. 2. 1. Notice of appeal. In order to launch a summary conviction appeal, a notice of appeal in Form 2 of the SCJ rules must be filed with the clerk of the court. R. 40.04. 2. Rule 40.05 of the SCJ rules sets out the time frames for launching an appeal. The rule mirrors the 30-day time frame for filing a notice of appeal in indictable appeals. An extension of time to file the notice of appeal can be sought pursuant to R. 40.03. Rule 40.06 deals with service of the notice. An accused person serves a notice of appeal by filing a copy with the clerk of the appeal court with proof of service on the office of the Attorney General designated for service of summary conviction appeals in the region. The Crown must personally serve the accused with the notice prior to filing a copy with proof of service with the clerk of the appeal court. 3. 2. 2 Transcripts. Rule 40.08 requires that, along with the notice of appeal, a court reporter's certificate or a written confirmation that the transcript has been ordered be filed. The written confirmation must be followed by the filing of the court reporter's certificate within 30 days. An appellant who has an application to legal aid pending or who has been granted a provisional legal aid certificate may file a notice of appeal without ordering the transcript. The certificate must be filed within 15 days after a legal aid certificate authorizing funding for the appeal is granted. The contents of the transcript are set out in R. 40.08. 13. As with indictable appeals, certain portions of the trial proceedings are not generally included in the transcript, but where the omitted areas are relevant to a ground of appeal, they may be obtained by a judge's order. Where all parties consent to the inclusion of additional portions of the proceedings, the order will be made without the attendance of counsel. R. 40.08. 14. In appeals where the evidence is not in dispute, an agreed statement of facts may be filed in place of the transcript, together with the reasons for judgment and reasons for sentence. RR 40.08. 6. 8. In sentence-only appeals where there was a trial after a plea of not guilty, the Crown and defense must make every effort to produce an agreed statement of facts. R. 40.08. 17. Assistance in settling the statement of facts can be obtained from a judge in chambers. Sub Rule 40.08. 23 encourages agreement on the facts by making unnecessary transcription of evidence a factor in determining whether costs should be awarded on the appeal. 2. Appeal books. The contents of the appeal book are set out in R40.10. 3. Within 15 days after the completion of the transcript or, where a transcript is not required, within 30 days of filing the notice of appeal. R40.10. 1. Requires that a copy of the appeal book be served on the respondent and filed with the court. 3. 2. 4 factums. The form for the appellants and respondents' factums in summary conviction appeals from conviction, conviction and sentence, and acquittal is described in R40.11. The factum in a sentence-only appeal is in Form 19. The appellant's factum in summary conviction appeals must be no longer than 20 pages. The respondent's factum is not to exceed 15 pages. The appellant's factum must be served and filed within 90 days of receiving the court reporter's certificate of completion. R40.11. 4. The respondent's factum must be served on the appellant and filed with the court no later than 10 days before the week in which the appeal is scheduled to be heard. R40.11. 6. 3. 2. 5. Setting a date when the transcript, appeal book, and appellant's factum have been filed. The appeal is perfected and may be placed on a list for hearing. R40.13. Once the appeal has been listed for hearing, the clerk of the appeal court will contact the parties and fix a date for the hearing of the appeal. R40.14. 3. 2. 6. Local practices and procedures. While the SCJ rules apply across the province, many jurisdictions have developed local practices that, at times, are inconsistent with the SCJ rules. The legal representative is advised to check with the court clerk to determine what local practices exist. 3.3. The hearing. A summary conviction appeal is heard before a single judge of the Superior Court of Justice. Counsel must be robed for pre-hearing motions and for the appeal itself. Sentence-only appeals are restricted to a half hour in total. R40.21. For all other appeals, a judge of the court will assign a time estimate for oral argument after the appellant's factum has been filed, subject to revision by the judge hearing the appeal. R40.20. 3.4 Powers of the Appeal Court. 3. 4. 1. Section 813 Appeals under S. 822 of the Code, SS 683-689, which delineate the powers of a court of appeal in indictable matters, are incorporated for summary conviction appeals. 3. 4. 2. Section 830 Appeals. In an appeal pursuant to S. 830, the appeal court may affirm, reverse, or modify the trial decision. S. 834. 1. Or remit the matter back to the trial court with the opinion of the summary conviction appeal court. S. 834. 1. B. 3.5 Further appeals pursuant to S. 839 of the Code. Both the accused and the Crown have a further right of appeal to the Court of Appeal for Ontario, with leave of the court or a judge thereof, on a question of law alone. Leave to appeal is granted sparingly, i.e., where there is a clear error of law or the case raises issues of law with broader significance to the administration of justice. 4. Stays of orders. Parliament has recognized that although an accused person has been convicted of a criminal offense, there may be circumstances in which it would be oppressive or unfair for the accused to have to comply with the terms of a sentencing order prior to the hearing of an appeal. Accordingly, provision has been made in the Code for certain sentencing orders to be stayed pending appeal. Pursuant to S. 683. 5. A judge of an appellate court has the power to stay the following pending an appeal: an obligation to pay a fine, an order of forfeiture or disposition of forfeited property, an order for restitution, an obligation to pay a victim surcharge, a probation order, and a conditional sentence order. A precondition for such an application is the filing of a notice of appeal. Before granting a stay under this subsection, the judge must be satisfied that the order is in the interests of justice. Where an accused person has been convicted of a code offense and sentenced to either a mandatory or discretionary driving prohibition, once an appeal has been taken against the conviction, an order staying the driving prohibition pending appeal may be obtained from a judge of the appeal court under S. 320.25. In order to obtain a stay, the accused bears the onus of establishing both of the following on a balance of probabilities. The appeal is not frivolous. The driving prohibition is not necessary in the public interest. When granting a stay pursuant to S. 320.25, the judge may place conditions on the accused, such as restricting the accused's driving to going to and from work or requiring the accused to refrain from driving for a specific period of time after consuming alcohol. In seeking a stay in relation to a summary conviction appeal, under either S683, 5 or 320.25 of the Code, R41 of the SCJ Rules sets out the appropriate procedure. The Crown must be served with the following materials 2 clear days prior to the application: a notice of application for the stay, a copy of the information, a copy of the notice of appeal, an affidavit from the accused, and any other supporting materials. Persuasive application materials will generally include a detailed notice of appeal, listing case-specific rather than boilerplate grounds of appeal, a copy of the trial judge's reasons, the applicant's driving and criminal records, a summary of the facts, and a detailed affidavit from the applicant describing the basis for a stay, including the hardship that would be suffered in the absence of the stay being granted. See, for example, RV1, where the Crown files a written consent to the stay. The order may be obtained without having to appear before the judge. If the order is not stayed pending appeal and the appellant is successful on appeal but convicted after a retrial, the time spent on the prohibition will count against any prohibition order imposed following the retrial. Where an accused person seeks leave to appeal a decision of a summary conviction appeal judge to the Court of Appeal in relation to a matter in which a driving prohibition has been made, the process for seeking leave and a stay of the driving prohibition is addressed in S16 of the Criminal Appeals Practice Direction. Leave must be granted before a stay is ordered. The applications for leave and for the stay are heard at the same time. Counsel must file a factum and an application record that includes an affidavit from the client along with any relevant transcripts. The criminal appeal rules do not specifically address the practice to be followed in seeking stays pending an indictable appeal. Accordingly, reference should be made to S7.2 of the Criminal Appeals Practice Direction dealing with motions before a single judge. 5. Bail pending appeal. Bail pending appeal has been recognized as a crucial aspect of the appellate process. Indeed, the Court of Appeal for Ontario has indicated that reviewability of convictions leading to imprisonment is a principle of fundamental justice under S7 of the Charter and that access to bail pending review is a necessary adjunct of an effective right of appeal. The outcome of an application for bail pending appeal can have serious implications for an accused person. In the appellate context, the accused no longer has the benefit of the presumption of innocence, nor is there a presumption in favor of release. Yet, a sense of injustice may be created where a person is denied bail following a conviction and is subsequently acquitted on appeal. Moreover, an unsuccessful release application can have a significant impact on the practical and strategic approach taken by counsel in the conduct of the appeal, even where the appeal is not rendered moot by the passage of time inherent in readying it to be heard. The pace at which the preparation of an appeal must proceed increases dramatically when the client is in custody. 5.1 Release pending an indictable appeal. Section 679 of the Code deals with applications for release from custody pending appeal in relation to indictable offenses. For the purposes of this provision, custody includes incarceration, a conditional sentence, and parole. Section 679 covers release pending an appeal to a court of appeal from a conviction alone, a sentence alone, or a conviction and sentence. It is also used in seeking bail. Pending an appeal or an application for leave to appeal to the Supreme Court of Canada. The prerequisite for any such application is the filing of a notice of appeal or a notice of application for leave to appeal. 5.1. 1 Criteria: appeals from conviction alone or conviction and sentence pursuant to S679. 3. The appellant may be granted bail pending appeal provided a judge of the Court of Appeal is satisfied of all of the following. The appeal or application for leave to appeal is not frivolous. The appellant will surrender into custody in accordance with the terms of the release order. The appellant's detention is not necessary in the public interest. The onus is on the applicant to satisfy the judge of each of these criteria on a balance of probabilities. The appeal is not frivolous. In order to fulfill this initial requirement for bail pending appeal, the appellant need only establish that there is an arguable ground of appeal. The courts have interpreted frivolous to mean the appeal is totally devoid of merit and could not possibly succeed. Some common methods of demonstrating that there is an arguable appeal are by filing a portion of the transcript to illustrate the error listed in the notice of appeal, by filing an affidavit from the appellant's trial counsel, or, where applicable, by providing the court with the opinion letter written by defense counsel in support of the appellant's legal aid application. B. the appellant will surrender. This second criterion is akin to the primary ground in S 515(10)(a) of the Code. In order to satisfy the surrender criterion, counsel will want to file material to establish that the appellant has roots in the community and, where applicable, that the appellant was on bail prior to conviction and fulfilled all of the conditions of release. Another common means of establishing that the appellant will surrender as required is to present viable sureties who are prepared to sign a declaration pledging a substantial amount of money to the Crown. A standard term of each order for release pending appeal is that the appellant surrender into custody by 6:00 p.m. on the day prior to the hearing of the appeal, failing which the appeal will be deemed abandoned. R33. C. Detention is not necessary in the public interest. The term public interest in S 679. 3. C encompasses considerations akin to those of the secondary ground in S 515(10)(b), which bear on the protection and safety of the public. However, public interest also includes considerations relating to the public perception of and confidence in the administration of justice. The public interest criterion was interpreted by the Supreme Court of Canada in R v Holland, where the court held that this component of the test will only rarely play a role in the decision of whether to grant bail pending appeal. That is, it will apply only in cases involving very serious offenses. It is in dealing with such serious offenses that public interest, as it relates to the public's confidence in the administration of justice, may support detention in custody. Yet, Parliament clearly envisaged that there would be some cases in which a person convicted of a serious violent offense, including murder, could properly be granted bail pending appeal. Circumstances in which release might be warranted in the public interest include any of the following. The hearing of the appeal is long delayed, and the probability of success is very strong. The appellant is the recipient of strong support and confidence in the community. There are compelling compassionate grounds. 5. 1. 2 criteria. Sentence. Only appeals. A precondition for bail pending a sentence appeal is that leave to appeal must have been granted. S 679. 1. B. In general, R31 of the Criminal Appeal Rules requires that the leave application be heard together with the application for release. To some extent, the issues in the leave application and the application for bail pending appeal overlap, since both involve a consideration of the merits of the appeal. However, if leave for a sentence-only appeal is denied, there is no right to appeal that decision to the full Court of Appeal. S 675. 4. Once leave to appeal is obtained, the appellant may be granted bail pending appeal pursuant to S 679. 4. If all of the following are established, the appeal has sufficient merit that, in the circumstances, it would cause unnecessary hardship if the appellant were detained in custody. The appellant will surrender into custody in accordance with the terms of the release order. The appellant's detention is not necessary in the public interest. The latter two criteria are identical to those discussed in relation to bail pending an appeal against conviction. A unnecessary hardship in addressing this requirement. One of the hardships commonly relied upon is that the sentence imposed on the appellant will have been served by the time the appeal can be heard, which would render the appeal moot. While this is a weighty consideration, it is not conclusive in itself, since the appellant must also demonstrate that the appeal has merit. Other circumstances that may be advanced as creating unnecessary hardship include a potential loss of employment, health reasons, and the likelihood of harm to the appellant's family. 5. 1. 3. Procedure for obtaining bail. In order to bring an application for bail pending appeal, counsel should prepare a package of documents that includes the following: a notice of application for release pending appeal, a copy of the notice of appeal, an affidavit from the appellant that complies with R32 and provides as much information as possible about the appellant's background and circumstances, and other materials in support of the application that are relevant to the statutory criteria, including affidavits from a spouse or other family member, an employer, a surety, or the appellant's trial counsel, portions of the trial transcript, reasons for judgment in a judge-alone trial, exhibits such as a pre-sentence report or a victim impact statement, and any relevant case law. These documents must be served on the Crown 3 clear days prior to the hearing of the application and filed with the Court of Appeal. R37. The Crown is entitled to file affidavits in support of the appellant's detention. Although this is not routinely done, the parties may cross-examine on any affidavits that are filed, and the transcripts of those cross-examinations should be provided to the court. R32. 3. 5. 1. For the hearing, an application for bail pending appeal is heard before a single judge of the Court of Appeal. Criminal Appeals Practice Direction. S. July 2, 2011. In appeals from sentence only, leave to appeal must be sought at the same time as the bail application. Criminal Appeal Rules. R31. Counsel, who are not robed, make submissions based on the materials filed. When the application is on consent, release will usually be granted on the agreed terms. In these circumstances, the parties should submit a draft order to the court. If bail is opposed or the terms of release are in dispute, the judge will proceed to hear the application. Usually judgment is given orally, immediately after the hearing, with brief reasons endorsed on the notice of motion 5. 1. 5. The order where the application for bail pending appeal is denied. The judge can order that the hearing of the appeal be expedited. When release is granted, it must be in the form of a release order referred to in S. 515. A judicial interim release order, pending trial, which may be adapted to suit the circumstances. S. 679. 5. For example, the appellant may be released on a release order with financial obligations with or without sureties, with or without a cash deposit, and with or without further conditions. S. 515. Ordinarily, release will be ordered on a release order with conditions including a financial pledge and with one or more sureties. Rule 33 sets out the mandatory conditions that are to be included in all orders for release from custody pending appeal. Subsection 679. 5. Provides that the release order must include a condition that the accused surrender into custody in accordance with the order. The order will also include terms that are relevant to the appellant's circumstances, such as requirements as to residence, employment, curfew, non-association, abstention from alcohol, and continuation of treatment. Counsel must ensure that the appellant is able to comply with the terms included in the bail order. Otherwise, the order may be breached and bail cancelled. If bail is granted, a release order must be prepared and sent to the jail to be signed by the appellant. The appellant's sureties must attend before a justice of the peace, typically at a local courthouse, to sign the surety declaration. If the appellant complies with the release order, the appellant must be immediately released from custody. S. 679. 5.1. 5. 1. 6. Altering the order. Variation of the order. A judge of the Court of Appeal has the power to vary an order for bail pending appeal made by that judge or another judge. No material change in circumstances is required before a variation can be made, provided that the appellant satisfies the statutory criteria for release. Once the variation is made, the appellant and the sureties, if any, are required to sign a new release order. B. Extension of the order. In order to ensure that an appeal is pursued with due diligence once bail is granted, a judge of the Court of Appeal will routinely include a sunset clause as a term of the release order. This term provides that the order will terminate on a specific date or on the date of the hearing of the appeal, whichever should occur first. Where the appeal cannot be heard prior to the specified termination date, an application may be brought for an extension of the release order. The material filed in support of such an application should include an assurance that the surety is willing to continue in that role, and information about the current status of the appeal, the remaining steps, if any, needed to perfect the appeal, any explanation for the failure to perfect the appeal before the expiry of the order, and the earliest feasible date on which the appeal could be heard. R34. 3. Where due diligence in perfecting the appeal is not established, an extension of the bail order may be denied. A judge can make an order varying or extending a release order without the attendance of counsel where the written consent of the Crown has been filed. R34. 2. Criminal Appeals Practice Direction. S. July 2, 2011. 4. C. Review of the order. The correctness of a decision granting or denying bail pending appeal may be reviewed pursuant to S. 680 of the Code. A challenge of this nature proceeds in 2 stages. Initially, an application for a direction that the court review the order must be made to the Chief Justice of the Court of Appeal. The procedure for initiating a S. 680 application is set out in S. July 2, 2012 of the Criminal Appeals Practice Direction. The test, to be applied by the Chief Justice in deciding if a review should be directed, is whether the court could possibly conclude that the initial application should have been allowed. Subsequently, if the direction is made, a panel of the Court of Appeal hears the review. The review is conducted as an ordinary appeal, with appeal books and factums being filed. Criminal Appeals Practice Direction. S. 7.3. The court has the authority to confirm or vary the initial order, where the correctness of the initial order granting or denying bail pending appeal is conceded but it is alleged that there has been a material change of circumstances. A second application before a single judge can be made under S-679. It is usually preferable for the judge who heard the initial application to deal with any subsequent bail applications. D. Revocation of the order. An order for bail pending appeal may be revoked where the appellant has violated or is about to violate the terms of the release order or where the appellant has committed an indictable offense. S-679. 6. Of the Code. When the appellant is out of custody, Crown Counsel will bring an application for a warrant for the arrest of the appellant before a judge of the Court of Appeal. Where a warrant is issued, the appellant may be brought before the judge and given an opportunity to show cause why the appellant should be released. The appellant may also be arrested without a warrant pursuant to S-495.1 of the Code where a peace officer has reasonable grounds to believe that the appellant has violated or is about to violate the terms of the release order. When the appellant is already in custody, no arrest warrant is necessary. It is sufficient if the appellant receives proper notice of the revocation application and has an opportunity to be represented by counsel at the revocation hearing. The judge may order the appellant released or may cancel the order, thereby reviving the original warrant of committal. 5.2 Release pending a new trial where an appeal has been heard, either by the Court of Appeal or the Supreme Court of Canada, and a new trial has been ordered. A judge of the appeal court has the jurisdiction to grant bail pending the new trial. The issue of release is to be determined under S-515 or 522 of the Code as if the appellant were charged with the offense for the first time. S-679. 7.1. 5.3 Release pending a summary conviction appeal. An application for bail pending a summary conviction appeal is made under S-816 or 832. 1. Of the Code before a judge of the Superior Court of Justice. As with indictable appeals, a prerequisite to a bail application in summary matters is the filing of a notice of appeal. 5.3. 1 Criteria. No test for the granting of bail in these circumstances has been set out in the Code. However, in R.V. Simpson, criteria for release, which mirror the requirements in S-679, were articulated. The appellant must establish all of the following. The appeal is not frivolous. The appellant will surrender himself or herself into custody in accordance with the terms of the release order. Release would not be contrary to the public interest. Where the appeal is from sentence only, the appellant must establish that the appeal has sufficient merit and that in the circumstances it would cause unnecessary hardship if the appellant were detained in custody. In general, the short sentences imposed for summary conviction offenses militate in favor of granting bail pending appeal. Otherwise, the delay inherent in the preparation of the trial transcript would result in the entire sentence being served before the appeal could be heard, thereby making the matter moot. 5.3. 2 Procedure for obtaining bail. The procedure for seeking bail pending a summary conviction appeal is set out in R42 of the SCJ rules. The appellant must prepare an application record containing a copy of the notice of application, a copy of the information, a copy of the notice of appeal and any supplementary notices of appeal, an affidavit of the appellant in compliance with R42.03. 2. And any other material that may be of assistance to the court. The Crown must be served with this material 2 clear days prior to the hearing of the application, and a copy of the material along with proof of service must be filed with the office of the Clerk of the Appeal Court. If the Crown takes the position that the appellant's detention is necessary in the public interest, an affidavit of any additional materials to be relied upon must be filed. The parties have the right to cross-examine on these affidavits. Where the Crown consents to the appellant's release, the materials can be filed along with a written consent and a draft order. The judge may grant bail without the need for the parties to appear. 6. Judicial review. Once a case has moved from the preliminary inquiry to the trial stage, extraordinary remedies, such as certiorari, are available where the trial court has made a jurisdictional error or an error of law on the face of the record. Applications for judicial review of a decision of a judge of the Ontario Court of Justice are dealt with in the Superior Court of Justice. An application to review a decision of a Superior Court of Justice judge must be brought by way of an application for leave to appeal to the Supreme Court of Canada pursuant to S40 of the Supreme Court Act. The discretion to grant an extraordinary remedy is rarely exercised in criminal cases. There are no interlocutory appeals in criminal matters. Judicial review of rulings made during the course of a trial. where there is an appellate remedy at the conclusion of the proceedings, cause unnecessary interruptions in the criminal process. However, in unusual circumstances, where the interests of justice require immediate intervention, the jurisdiction to grant an extraordinary remedy will be exercised. This is most commonly seen where the interests of a third party, not directly involved in the criminal proceedings, are at stake, such as the media in Dagenet v Canadian Broadcasting Corp or the lawyer who was not permitted to withdraw his services in R.V. Cunningham 7. Post-appellate remedies pursuant to S. 696.1 of the Code. An application may be made to the Minister of Justice to review a conviction or a finding that a person is a dangerous or long-term offender on the basis of a miscarriage of justice. This application can only be made after all appellate remedies have been exhausted. The minister's ability to address a miscarriage of justice is only exercised in exceptional cases where there is new and significant information that casts doubt on the correctness of the person's conviction. S. 696.4. Upon receiving an application, the minister will conduct a preliminary assessment to determine whether to start an investigation. Where there is a reasonable basis to conclude that a miscarriage of justice likely occurred, an investigation will take place. The minister may exercise the powers of a commissioner under the Inquiries Act in carrying out the investigation or may delegate conduct of the investigation to a lawyer, retired judge, or other appropriate person. S. 696.2. At the conclusion of the investigation, the minister may dismiss the application, or if satisfied that a miscarriage of justice likely occurred, the minister may order a new trial or hearing or refer the matter to the Court of Appeal for hearing and determination. S. 696.3.